All right. Hello, everyone, and welcome to RNG Presents One Nation Under God. I'm so excited to be here. This is going to be such a fun afternoon. I'm Pieklo, Rewire News Group's Senior Vice President and Executive Editor. More importantly, though, I am joined by some of the best legal minds in the country right now. And I say that in all sincerity. We have Imani Gandy, my esteemed co-host of the Moderator podcast and Rewire News Group's editor-at-large. We have Chase Strangio, Deputy Director for Transgender Justice with the ACLU's LGBT and HIV project, and a nationally recognized expert on transgender rights. We have Andrew Seidel, author of American Crusade, How the Supreme Court is Weaponizing Religious Freedom, and civil rights attorney. And we are here to talk about the Supreme Court. But more importantly, we're going to talk about how the Supreme Court is operating now to put in place a very specific agenda. I hope that this is a freewheeling and open discussion we've got some time at the end for questions. This is part of a week-long focus that we've done over at Rewire News Group on the topic of the court and how it's operating right now in a way that's not great if you happen to be not white, not Christian, not cisgendered. If you haven't had a chance yet, please go over to rewirenewsgroup.com and check out the offerings that we have there. We have some tremendous contributions. We have a wonderful photo essay. Please go check it out. Quick note on the rules before we really dive in. There are no rules. No, I'm kidding. This is, like I said, an open discussion. I've got a couple questions and we're going to then open it up from there. If you have them, please drop them in the chat. It is a moderated chat. They will get to me at the end. And if we don't get to your question, you can submit them and I will do my best to follow up. I anticipate, given the fact that we have 4 lawyers on this conversation, that things will kind of go once we really start. So I'm going to stop talking because nobody's here to hear me. We are here to hear from these wonderful folks. It's been a heck of a week at the Supreme Court, to say the least. One of the cases that we're going to focus on in this hour and start with is a case out of Colorado, of all places, my home state. 303 Creative. And this is a case that involves a website designer who refuses to make wedding sites for same-sex couples. It is a straight up religious imposition type of case. It's also a case engineered by the Alliance Defending Freedom. And as Imani and I talked about on our podcast, Boom Layered, this week, it poses an existential threat to non-discrimination laws generally. If the court sides with the plaintiffs, the claimants in this case, it could grant business owners a license to discriminate based on their religious belief, in this case, dressed up as opposition to same-sex marriage. Alliance Defending Freedom is also behind the wave of anti-trans bills that we've seen sweeping the states. It's no surprise that we see them in both of these places. And so I want to open up the conversation and turn it to you, Chase, and ask, what should our audience know about the Alliance Defending Freedom and how they get these kinds of cases like 303 Creative to the Supreme Court? Because this is designed to be a test case, is it not?
Yeah, no, I mean, well, thank you for having me. It's so good to be here. I have to admit that I didn't even listen to the 303 Creative arguments because I just didn't have it in me this week. I got out of trial last week and it was 5 years to the day after Masterpiece Cake Shop arguments, which some folks may remember was basically the similar sort of fact pattern, although in Masterpiece there was an actual person and an actual business and an actual couple who went in to get a cake. That is not the case with the 303 Creative case. She didn't make wedding websites. I don't even know if we can call her a web designer. I don't know. She just is a person who maybe in the future aspires to do things, but obviously this is all a set, it's a case that is built on a set of hypotheticals, which we know that when we get up to the Supreme Court, everything becomes about hypotheticals. But this is deeply disturbing because there is no actual conflict yet. It's not clear, A, what a public accommodation is under Colorado law. So they did not go clarify the clear state law question before going up to the Supreme Court, sort of one unclear thing, because, she didn't. The agency charged with enforcing the civil rights law had not enforced it against her. And that's what's, different than in Masterpiece, for example, where you did have someone who was turned away, who then filed a complaint. And one of the reasons why that's so important is that in the public discourse, that meant there was another person who could be seen as harmed by the actions. And that was the gay couple who were turned away from being able to have their wedding cake. In Masterpiece, here, there is no person who's injured. Well, I mean, ADF believes that the website designer is injured as a hypothetical injury, a hypothetical future injury, but there's no sort of story to tell on the other side. And this is very strategic on ADF's part. And we saw that, they end up getting these really sympathetic sort of front page stories about their client being placed as, she's this white Christian woman, and she's, photographed in like a halo lighting. And, it's like this poor woman has to, it's like, it's actually unbelievable that it's being covered so effectively, but for their cause. But she is the victim, the only victim. Everyone else is a hypothetical, including, all of the individuals who are just the butt of Justice Alito's jokes in the course of the argument. And when you pitch it as this completely contrived scenario, it allows for all of the actual real structural discrimination in the United States to similarly become a hypothetical joke to the justices who are already predisposed to believe that. And so I think, sort of at its core, ADF manufactured this lawsuit for purposes of bringing a new case up to the Supreme Court with a new set of justices who would be more sympathetic to their position. And it is actually just a First Amendment. I mean, this is just a compelled speech case at this point, but the entire narrative is one of this woman's infringement upon her hypothetical infringement, I should say, upon her religious beliefs. And ADF is incredibly effective at sort of monopolizing the media narrative. They bring these test cases at the same time that they are drafting model legislation all around the country and pushing out a narrative about, actual individuals who wield quite a lot of power being victims of non-discrimination law. And so I think that when we're listening to and looking at the cultural context of these various Supreme Court cases, we really have to take a step back and sort of look at all of the information that we're being fed by these very far right-wing groups that are trying to evoke a particular set of stories. And unfortunately, the media is quite complicit in helping them do that. And that's sort of what I got out of the 303 creative arguments and the entirety of the case, which is that as just a bystander of, sort of media consumption in the United States, you could come away thinking that this woman was in some way harmed, and that there is no one else whose interests are at stake in these cases. And I think that is one of the scary things about how effectively ADF is maneuvering, not just in the legal landscape, but in the media one.
I'm so grateful that you brought up the fact that there is no couple, there is no person here who is actually asking this website designer to do anything. Because Andrew, you covered Masterpiece Cake Shop in that case in your book quite a bit, and know the couple that was at the center of that case, and the difference in having people who have been harmed, who have been turned away in that case. We actually, say more about that. I mean, you have an entire chapter in your book about that. And that stark difference that we have here now is, as Chase said, a very intentional one by ADF, don't you think?
Oh, absolutely. I mean, it was intentional. It was diabolical. It was brilliant. I mean, and it was something, it was also not just the anniversary of the Masterpiece Cake Shop case. It was actually Charlie Craig and Dave Mullen's anniversary proper as well, the day they heard argument on this. Yeah, I had drinks and dinner with them a couple of weeks ago when I was doing a book talk in Denver, and we were talking about this case, and they recognized very clearly, like, this is the reason the court also took this case. Not just ADF, but the court was so eager to take this case is because there is no real victim in it. As Chase was pointing out, there's no victim of discrimination in the case. It's all entirely hypothetical. The company has never designed websites, wedding websites, never been asked to design wedding websites. It's never denied service to anybody. It's never had the civil rights law enforced against us. So the case is artificial, hypothetical, manufactured. The legal term of art here is bullshit. And it should not be before the court, which is a very, very bad sign. And one of the things that I try to point out in American Crusade, the new book, is that this court wants to take these cases. It's desperate to take these cases. In fact, we know the court rejects something like 97 to 99% of the cases that come its way. But when it comes to a case that could privilege conservative, white, cis, het, Christian America, it will jump on those cases. It'll ignore procedure, it'll ignore precedent, and anything to take those cases. And the pretextual reason that ADF has offered for the court to latch onto in this case is that, oh, well, the company wants to expand into the wedding website arena, right? Like now it just designs church websites and websites for Republican politicians. And it wants to expand there and post a sign, which is the digital equivalent of no blacks, no Jews, no Irish. It wants to publicly say, we are not going to offer service to LGBTQ people. And it can't do that because of the civil rights laws. And that to me is just the crucial point here. This is, as you said at the beginning, a direct attempt to completely undermine civil rights laws. And we know that these laws work. They're hugely important. The shift in public opinion against segregation and racism in the 60s and 70s is due in no small part to the fact that civil rights laws mandated equal treatment. Justice Sotomayor actually explained this to the bakery at the end of oral argument in Masterpiece Cake Shop case. She was talking about America's reaction to mixed marriages, mixed race marriages, and how it didn't change on its own. It only changed because we had public accommodation laws that forced people to do things that many claimed were against their expressive and religious rights. So these laws work. And historically, the idea that your freedom of speech or freedom of religion trumps civil rights was laughed off by the court. Yes. I mean, laughed off in a footnote, literally, in an early case.
Yes, the weaponization of the First Amendment by the conservative legal movement, I think, is one of the most underreported stories in the legal spaces. So it makes a lot of sense why, this group would be talking about a case like 303 Creative, but the Supreme Court also heard arguments this week in Moore versus Harper, a case that honestly poses an existential threat to democracy. I'm not being hysterical when I say that, but one that might not be as immediately apparent in its ties to the conservative legal project that we're talking about. And my colleague Imani Gandy absolutely crushed coverage of the case this week. And I just want to kind of open it up to you, because can you sum up for folks why a bunch of, repro civil rights folks are talking about the independent state legislative theory? What's going on here? What's this case about, and why are we talking about it in this context?
It's about cracking open democracy. It's about privileging certain voices. It's about erasing from the political, public square, the voices of Black and Brown people, the voices of LGBTQ people, the voices of women and people capable of becoming pregnant. And, RNG focuses on repro, and it may seem like Moore versus Harper is not exactly tied to repro rights, but it 100% is, because the only way that people in a state are going to be able to vote for people who will uphold their bodily autonomy, right, who will somehow reverse this tailspin we're in, where the Supreme Court has told women and people capable of becoming pregnant that we're not full citizens of this country. We are second-class citizens, and what's the contents of our womb, or the potential contents of our womb, are more important than any of the civil and human rights that we as actual already born people have. And so what concerns me about Moore versus Harper, which is this idea that North Carolina Republicans they created a congressional map that the North Carolina Supreme Court found was invalid. And the North Carolina Supreme Court said, hey guys, do you want to maybe draw a map that's not so partisan gerrymandered? And they just kind of said, not really. And so the, the Supreme Court said, okay, well, we're going to do it for you. And they did. And we're told, you know, Republicans were told, you have to run the next election on this map. And so the Republicans came up with this theory that has been rejected for nearly 20 years since William Rehnquist first proposed it, or at least proposed it, and it became part of the, you know, societal consciousness. This idea that state courts don't have a say in what state legislatures do. Mm-hmm. This idea that state legislatures can draw maps, they can gerrymander these maps to the hilt, and if they are in violation of the state constitution, the state Supreme Court, state lower courts don't have a voice in essentially applying state constitutional law to the activity of the legislature. And this is just absurd. It's an absurd proposition because the state constitution creates the state legislature, right? It imbues the legislature with the power, and it does so with the sort of understanding, the express understanding that state courts are going to make sure that they can judicially review state legislative action. And more importantly, the framers certainly didn't understand the word legislature, right? This is all a debate about the elections clause and about how state legislatures can set the time, place, and manner of federal elections. The framers understood state legislature to be the entire legislative apparatus, including governor's vetoes, right? Including the state constitution. What does the state constitution say about elections? Well, let's go ask the state Supreme Court, which interprets the state constitution. But that's apparently not something Republicans are willing to do anymore because they don't want to be beholden to their own state constitutions. And what concerns me about this case, because I've been sort of following the reaction in the media about this case, and I really haven't heard a lot of people talking about the fact that, like 303 Creative, this case doesn't need to be before the Supreme Court. The Supreme Court had no business taking this case because even if they buy this independent state legislature theory, even if they think that that is what the framers wanted and what everyone should abide by, in North Carolina, the North Carolina General Assembly, right, the state legislature of North Carolina specifically authorized North Carolina state courts to judicially review redistricting maps. They specifically authorized it. And now they're claiming before the Supreme Court that somehow the state Supreme Court usurped the legislature's authority when it threw out the crappy map and said, you're going to run this election on a map that's more fair.
Yeah.
The legislature can't usurp something it was specifically told it could do. And people aren't talking about that. And I think that generally speaks to the corruption of this court, and that they will, as Chase said, take any case, do anything, ignore procedure, institutional norms in order to come out to a result that benefits Christian, white, cis, het America.
That is an entire word. And you're not at all, I mean, it is all correct. One of the things that is really enjoyable about moderating a discussion like this is I get to kind of bask in the brilliance, but then I find myself tripping over all of the follow-up questions that I want to ask, because immediately we have a theme that's emerged, and I didn't even put that out there intentionally, which is, I mean, but I love that because you guys are so great at this. We have these campaigns by groups like the, Alliance Defending Freedom, for example, and now a court that is really working hand in hand with them, to the points that Andrew and Chase have made about willing to step in cases that there are no controversies, right? That was the case with Dobbs. There was no controversy around whether or not pre-viability abortion bans were unconstitutional. At the time, they were not. Those were some of the signals that we have. We have that with the Burkine case, which is another campaign that we've seen come up before the case. And that one, in that case, Burkine versus Holland, the court heard arguments in November. That is a campaign to try and upend the Indian Child Welfare Act. And it is a campaign by white evangelicals. And they have been working on this for decades. I think I covered the first lawsuit in Burkine in 2018, for example, to give you a sense of that. I'm just kind of at a loss. Andrew, your organization, Americans United for the Separation of Church and State, like, you are in these spaces all the time. How is it that the conservative legal movement right now is operating with such efficiency?
Well, I mean, I think it's because they have allies on the court itself. I mean, this is, for the most part, a collaborative effort, right? That they bring these cases, they set them up, and then the conservative justices on the Supreme Court come and knock them down. I mean, we can look back to the end of last term, right? In the Coach Kennedy case, which is the case that Americans United argued, right? The coach moved to Florida before the Supreme Court took that case. The only relief he asked for was to be reinstated as a coach in Washington State, right? The court had no business hearing that case. In the Carson versus Macon case, which the Supreme Court said for the first time ever that state governments have to use their taxing power to take money from citizens and turn around and give that to religious entities. In that case, the schools, the religious schools, didn't even say they were going to take that money if it was possibly offered, because they didn't want to take along the government regulation that would have come with it. There's no standing for the parents in that case. And this is a time and time and time again. In the Trinity Lutheran case, we saw this in 2018, where all the parties agreed on the outcome of the case, and still the Supreme Court took it to decide in favor of conservative white Christian Americans getting more. So time and time again, it's the conservative justices on the Supreme Court allying themselves with the religious right, this Christian nationalist movement, to really enshrine and reclaim their lost power, privilege, and status.
And I think just something that is so incredibly frustrating as a litigator is that, like, it is so hard for us to be able to plead in a pre-enforcement context to be able to get standing in federal court. And yet there's like the universal standing principle for like the white conservative Christian plaintiff. It's like, it's obviously it's in the 303 creative, like, of course she has standing, even though nothing has ever happened. It's all a set of hypotheticals, and I think obviously there is broader standing in the First Amendment context, but this is an ongoing theme. If you look at someone like Abigail Fisher, who challenged affirmative action for like 3,000 years, she was out of college and they still took the case. She was like 100 years old. And yet, like, our cases are always moot. We never have standing, and so it's just, and my colleague Josh Bach pointed this out too. It's like the willingness of the court to hear the claims in 303 creative versus what was going on with SB 8 and the efforts to sort of bring these pre-enforcement challenges, and how the court was like completely and utterly incredulous. They're like, why are you here? You have to go to state court, where it's like that none of that was present. And so looking too about how these things, like procedural mechanisms in law, are very systematically deployed to favor some litigants over others. And that is just so clear in this court in particular. Or looking at like the affirmative action cases argued last month, it's like there was no trial. They didn't care about facts that, and so like things that are like, what is the purpose of appellate review? Apparently it's not to review the facts that were decided by the court. Like, why have trials? And so I think that these principles of standing, of mootness, of deference to district court fact finding, it just doesn't matter in a completely ideological court that has no regard for evenly applying principles. And to be clear, that's always been true. I mean, Fisher, that was, 10 years ago, that's been the case, and that has always been true, but it's just so transparent at the moment. And that the facts, like in the Coach Kennedy case, it was like a ridiculous proposition. And yet here we are.
Yeah.
Oh, go on.
I was just going to say, that's why I moved out of litigation. Like, I was a litigator for 10 years doing this work, and I don't think it's worth doing anymore. I think it's more important to communicate and try to fight the media battle, because Chase, you mentioned in your opening, I mean, the other side is so successful there at manipulating the media and spreading this misinformation. That's where I'm spending my time these days, because I don't think it's worth spending my time having these arguments with the court when the deck is so stacked against us.
I think the same thing holds true for the Burkine case, the ICWA case, right?
Mm-hmm.
I mean, Rebecca Nagel, who she's an independent journalist and she does this great podcast, This Land, she has openly criticized the New York Times and other mainstream outlets that are telling the story improperly, right? That are eliding the actual facts of the story and making it seem as if that, you know, these poor white evangelical parents who had been raising this baby from birth were somehow being harmed by not being able to jump in front of the line that was specifically created in order to make sure that Native children grew up within their culture. They want to jump that line, and they're white and they're Christian, and they should be allowed to do that. And when they couldn't afford to make these ridiculous complaints anymore, then here comes Gibson, Dunn and Crutcher, which is one of the biggest law firms in the country, to do a custody battle. It was at bottom a custody battle, but it's not if you think about where tribal lands are located. If you start thinking about Standing Rock and fracking and oil and the money in casinos. I mean, this is an effort to undermine tribal sovereignty couched as a custody battle, which is, I find, fascinating.
And terrible. So one of the things that Imani and I run into on the podcast is really trying to just not like fall into straight nihilistic despair, because the fights matter, our rights matter, and we have only limited venues in which to defend them. So Chase, as the person actually doing litigation in the federal courts right now, how are you doing? Like, truly, how are you holding up? You kind of jumped into the question that I was going to ask you, which is, you know, how are you thinking about the rights of your clients and coming into these spaces that, as you said, seem very clearly to already be predisposed against them?
Yeah, so I mean, I guess the first thing is I've always been deeply cynical about litigation, about law. So it's not like, a lot of people, it was like Dobbs happened and they were like, oh God, there's this like grave injustice. I was like, well, like, that is how I've always felt. And so I always knew that I was engaging in a deeply compromised project. It wasn't like I was doing it with the idea that this was the path towards liberation. It's always been a harm reduction project for me. I always expect bad outcomes. And, I think that that's part of what is true when you're dealing with a violent system, which was what I believe law to be. At the same time, I use it as a tool. And I think, so two things. The first is we are still able to win sometimes in district courts. And so if you get an injunction in place that, it could last for a year, it could last for 2, it could last for 5. That may be 5 years where someone's getting abortion, having access to abortion, getting access to healthcare that they would otherwise not have because of these deeply awful state legislative actions that are blocking their care. So, I was in trial in Arkansas. We've had a PI in place, a preliminary injunction in place on their ban on healthcare for trans adolescents since July of 2021. It's probably going to get overturned eventually at the 8th Circuit or the Supreme Court. And that is a really scary eventuality, but it has been blocked for 1.5 years and it will be blocked for longer. And so I think that that's part of it. It's like every day that you're stopping something bad is still an important intervention. And that's what I keep telling myself, is what I tell my colleagues, is what I tell younger lawyers. It's like, yes, this is awful. And the Supreme Court is a disaster. Let's try to stay away from it. And also, if we have an injunction in place for 2 years, that's 2 years of something, of a material change for people. But I do think, to what all of you have been saying, is this is a battle in the public discourse. Like, we have to be better at telling these stories and exposing the truth, the lie of the sort of American constitutional project. And that feels deeply important because, the New York Times coverage of so many issues is atrocious, and they just like fall for like ADF's narrative, hook, line, and sinker. And that is changing the outcomes of the cases, because we are going before judges who are human beings, who are similarly internalizing, as are their clerks, as are their families, whatever the cultural landscape is producing. And so I will continue to litigate, as deeply frustrating and limiting as that is. But I also think ultimately the more important battles are the discursive and cultural ones.
That public messaging is so important. And to see, Imani and I have talked about that frustrating, but I appreciate that we have sort of the full spectrum on this panel, folks doing messaging in media, doing messaging in litigation, because I do think that litigation is its own form of messaging as well. Like, getting those findings of facts matter, right? Like those that is real. And I'm absolutely borrowing your universal standing principle. You will hear that on the podcast as well. But I guess, open it up to the panelists. Why do you think we have been so poor on that messaging in the public domain, whether it's media, whether it's even, larger advocacy organizations not willing to fully take the gloves off at a time when we need the gloves all the way off? Why?
Because people are so beholden to institutions. And I have found that even in the media landscape, the people who are less beholden to institutions tend to be people of color and tend to be LGBT people. And I'm going to say T people, because there are a couple of people who I think who are gay men who are still a little bit too, things might be okay. Amy Coney Barrett might actually have some common sense. And in the long run, maybe she does. But I feel like if you are writing articles for your Substack, I mean, I'm basically subtweeting people on this call right now. But if you're writing articles for your journal or for your Substack or for whatever media outlet, if you're not starting from the place, at least in your mind, that this is the Supreme Court that is compromised, then I don't think you're doing your readers a good service, right? Because perhaps 10 years ago, you could have said, well, there's precedent that says the electors have to be chosen before election day. So it is ridiculous that there's so many progressive legal scholars who are freaking out and thinking Moore v. Harper is going to allow Trump to steal an election. But he stormed the Capitol, right? One of the justices' wife was advancing the independent state legislature theory as part of her insurrectionist activity. This person's wife has access to his clerks, right? We have people who were on the Bush team, the Bush v. Gore team, where that theory was advanced, who are now on the Supreme Court, including Amy Coney Barrett, right? So if you're thinking Amy Coney Barrett is going to save you and you're not talking about the fact that she was on the legal team where this theory was advanced, you're doing yourself a disservice and you're doing your readership a disservice. And I don't want to have to see you in 5 years write an article about how you were wrong. Let's just get it right to jump.
I definitely agree with that. I think there's a veneration for institutions that sometimes clouds people's judgment. I'll say it that way, to put it mildly. I think the media deserves a little bit of blame here for prizing balance over truth, which is especially problematic in the context of legal cases and trying to both sides it. The New York Times daily episode on the Kennedy v. Bremerton case is a perfect example of that. I also think that there is a real danger, and this is one reason I'm loving this conversation, in talking about these cases as one-offs and not as something very different and very deliberate, that they are part of a manufactured and coordinated long-term push to privilege conservative white Christian America. I mean, they're part of a crusade. That's why my new book is called American Crusade. And we are seeing a judicial push really to empower Christian nationalism. And it starts with this packed Supreme Court. And they are collaborating with this well-funded and powerful network of Christian nationalist organizations that are deliberately working to warp and pervert our Constitution into something that will serve their means and ends.
Chase, how can those of us in media get it better?
I mean, I think it's two things that Andrew and Imani said. The first is to sort of expose the premise, like this, don't come at this like there's it's like, oh, like so-and-so filed this case because she was so concerned about her website. Like, just say what is true, which is that, she was picked by an organization that has a set of interests, and we are seeing a court that genuinely decides cases differently based on who the litigants are. And let's just at least expose it. So it's sort of partly telling a fuller, truer story, and then not doing the both sides, because or if you're going to do it, say this side is oriented this way and is part of this legacy, and sort of give some fucking context. Like, if we're talking about the Indian Child Welfare Act, talk about the history of stealing Native children. Like, talk about the violence of the so-called child welfare system. We need more context. Readers need more context. It's like, one of the things that is so infuriating to me about the New York Times coverage of trans issues and trans bodies is like, there is no fucking context. They're like, we decided we're going to have this conversation about the risks of puberty blockers as if that is existing in a vacuum. No, you are taking up a very right-wing talking point. You are not interested in this issue. You're not someone who studies the side effects of medication. You're not someone who's like, oh, like, how do we weigh the risks and benefits of medication? That is like a universal fucking problem, but it doesn't get front page coverage at the New York Times. And so I think it's just like, we need that, the sort of, to be reminded of the deeply sort of violent histories that are being played out quite strategically in the context of all these cases, whether that's like the battle over like the continued like legacy of the histories of indigenous genocide and enslavement in this country, whether that's the way in which trans bodies are posited as threat, whether that's how the legal system is always adopting to favor white, Christian, heterosexual, cisgender people. We need that because people don't really understand law and people don't really understand the sort of like nuances of the conflicts before the court, but they need to be told that this is part of something deep that is impacting their lives in a multitude of ways. And we don't get that. What we get are concern. It's like the police press releases. Like, we get the police press releases as journalism. We get the ADF press releases as journalism. I think that is deeply, that has just very material consequences. And I just am watching it get worse and worse.
And also, if I might jump in and add, just when when they start talking about, you know, these Christian white evangelicals as victims, I find it very interesting that the only corollary that they could come up with, they try to liken their trauma to the trauma that Black people have faced throughout this country, right? Like, the worst thing that they can think of is a Black kid in a KKK outfit sitting on Black Santa's lap. Like, and that's a joke to Alito, right? They're constantly sort of using Black pain and trauma to leverage these claims of reverse racism or persecution, right? They are leveraging false history to make claims, for example, in the affirmative action case, that affirmative action is reverse racist. I mean, it's, you know, that's what I love about Justice Jackson being on the court this term. I love that about her, because she's not letting them get away with this bullshit, right? She will go back and read the Joint Committee on, you know, in 1862 or 61 or whatever, and talk about, yeah, when they wrote the Equal Protection Clause, they were writing it for Black people. They weren't writing it for Abigail Fisher, who had crappy grades and couldn't get into the University of Texas. Yeah. And so I think the more, you know, she's become a truth teller on the court. And so I see, like, if the media can't do the job that Jackson is doing while she's also cabined in by her role as a Supreme Court justice, then what is the media even doing, right? Like, tell the story of the Equal Protection Clause. How hard is that to do? Even if it's just in a sentence, right? I mean,
yeah, it can be a fucking sentence. Just put in a sentence, like put in some goddamn history. Like, it's not that hard. She's doing it. She's like, no, that's not true. And she's like, this is what it means. There is no race neutrality in a fucking amendment that was about race.
Yeah, so we have questions that are starting to pile up in the queue, and I want to make sure and get to them. But before we do, I have one question for both Andrew and Chase. Since you exist in different areas in this space broadly, what are whether it's the appellate pipeline, what's on your radar that we should be really paying attention to coming up that could likely land before the court, that we, you know, whether it's Imani and I on the podcast that we can elevate, or the folks who are on this discussion with us need to know what's an issue, what's a case that that's really it for you right now? Chase, I'll start with you. I'm guessing your trial. I
guess I'm so nervous about sort of what is the future of trans cases before this court. And we have, unfortunately, I think the en banc 11th Circuit is going to overturn a restroom case. many states are trying to sort of, get either sort of a trans sports case, trans restroom case up before the Supreme Court. I don't know what's going to be first. So we had this trial over the healthcare ban. We had the PI. Miraculously, we won at the 8th Circuit, and they've denied rehearing en banc. So we have a good 8th Circuit opinion on the appeal of the PI. The 11th Circuit just heard an appeal out of Alabama. So there could be a circuit split on the healthcare issue, just on the PIs. We will, hopefully have a final injunction soon in our favor after trial. And then, just watching sort of as these issues go up, but it's not independent of like the future of abortion litigation, sort of where are these cases going? And then also all of the First Amendment issues that are going to come up in these attempts to ban and criminalize drag performance, which is like the new legislative thing. So how, A, do those laws pass? B, of course, we'll sue over them. And then what happens in the courts there? And are we going back to like criminal cross-dressing laws? Is that like the trajectory here? And is that going to go up? So just sort of really watching as these cases make their way through the courts. And, we have to contend with the appellate courts and the Supreme Court, which is obviously a scary prospect.
We're going to have you back to talk about all of that just for an hour alone. Andrew, what's on your radar right now?
Yeah, I mean, there's so much. We're also going to be going on the offensive shortly, so I'd love to come back and talk about that in late January, probably. For us, the end of Roe is in a way just the beginning. I do believe the crusaders that we have been talking about are coming for contraception. They're coming for marriage equality. They're coming for everything. So we are keeping our eyes out for everything. More specifically in our arena, there's some sort of esoteric things like the ministerial exception, which essentially allows employers to claim that their employees have some sort of religious duties and then turn around and fire them without cause and in violation of all their employment protections. We are seeing these groups, especially led by the Beckett Fund for Religious Liberty, working to expand that. That's something that we've been doing a lot of work trying to prevent. And there's a couple cases in the pipeline that we're watching closely. That's probably the one that is, I guess, might be the sleeper one that people are not paying attention to, because when you say ministerial exception, they're like, what? I don't know what that is.
Ministerial exception is basically anybody can be a minister in your business, and then
Yeah, and that's when it gets scary. It's when the for-profit companies like Hobby Lobby decide, oh, everybody whom we employ is a minister, and then you can see where it goes.
Yeah. Really allows the sort of weaponization, again, of constitutional principles for proactive discrimination against folks. Okay, so let's see if we can get to some of these questions. The first one I have, and I'm just going to open it up so y'all can just jump in. If 303 wins, does that then allow atheist-owned businesses to refuse customers who want them to speak Christian messages?
No, because these cases don't inure to the benefit of anyone who isn't white, Christian, cis het, right? It's the same thing, if you were to ask, well, people will say, oh, I'd love to see a Muslim before the court making that argument. Yeah, they would throw that Muslim out of the court because they're not here for the rights of minority or minoritized or marginalized people. So, I mean, right, the Satanic Temple, right, has in the past tried to bring these claims, and no one is going to say that the Satanic Temple has a right to avoid abortion bans because in their particular philosophy, they believe in bodily autonomy, and that's part of their anti-religion religion. I mean, this isn't fair. I mean, I think if you start from the position that the Supreme Court is not fair, I think that's where you end up.
Yeah. These don't go both ways. Like, you can cite the case, but it doesn't apply to you. I mean, the Muslim ban wasn't religious, wasn't discrimination, but the, Masterpiece Cake Shop was discriminated against. Same term, same court.
Yeah, within weeks of each other.
They're going to say drag shows should be banned, but cakes are creative expression, but a drag show is not creative expression. How's that going to work? They're going to figure it away. They're going to figure out a way.
The short version, this court does not understand religious freedom as a universal freedom, but as a Christian privilege.
Yeah, I think that's an excellent way to say it. And I think that's a message that's getting carried out, right? We saw recently in the news, there was a couple that had been denied a service, an evangelical couple, and they're arguing that that is discrimination, while in the same week, the court really honestly considered whether or not establishments can turn away whole cloth folks based on beliefs. So I agree.
But you know, when all religions will get to discriminate is they have the new, there's a case that was brought by Stephen Miller's new America First, or what the hell, he has that is brought on behalf of religious Muslim and Christian parents and children who don't want to share restrooms with trans kids, bringing, you guessed it, free exercise claims. So I think you can imagine, like, as long as the faith you're expressing is in service of Christian nationalism, then they will recognize it. And so it's not the individual identity, it's the structural imperative. And we are going to start to see those. And there have been a few cases that have exploited that, sort of Christian nationalist structure in the service of these, free exercise claims on behalf of Muslim individuals in the service of discriminating against trans people.
I don't even know. That's just, yes, it's. So one of the questions that to follow up on that is, and I think it's actually honestly kind of perfect, is what can we do to combat the fundamental and willful ignorance and dehumanization that's going on right now? Like, we've talked about the failings. What can we do to combat that?
Okay, I'll go first. One of the things I think we have to tell our side of this story, and we have to do it a lot more forcefully than we have been. That's what I was trying to do in the new book, is to really tell the truth about every one of these cases that have come before the Supreme Court in the last 10 years, and how they've warped and tortured what has been relatively simple legal questions in order to privilege this dwindling majority. I also think what Imani said earlier about this deference and faith that we have in institutions needs to be re-examined, and also what that looks like. Like, if you're an institutionalist, the fact that the Supreme Court has been taken over and packed, that should concern you. And if you are an institutionalist, you should want to fix that, not pretend as though the institution is okay just because the number 9 still exists as the number of justices there. I'll leave it at that for a minute.
Yeah, I mean, I think it's exactly that. Like, this is about reclaiming the truth of the stories that we tell, and telling them more, and just telling them better. We just have to, keep investing in the work of, of the storytelling in the courtroom, like invest in the storytelling of organizers, invest in sort of fuller media narratives, because we can't just sort of throw up our hands and be like, well, these institutions are broken, let's just do nothing, or let's just join them. Like, that we have to be bolder than that. And that just feels so critically important. And there is still so much good work to be done. People have been fighting so hard for so long. It's not that there's nothing that that we can do. We just have to be better, and we can't be so we can't be so quick to adopt their framing from like top to bottom, like critical race theory. Like, Christopher Rufo coined that for a strategic purpose, and he is the same person, mind you, that is telling people to talk about drag as sexually explicit whatever performance and using groomer narrative. These are the same individual humans who are pushing out narratives for ideological and structural purposes. We can't just be like, is there too much critical race theory in school? Like, how did we get there? That's ridiculous. We took every aspect of the words and the narrative that they fed us, and then tried to play by their terms. Like, that, we can't do that.
Yeah. Imani? Oh, wait.
I don't have anything to add that hasn't already been said, but I particularly love Chase's point about you can really tie these sort of manufactured crises to the same people. I mean, it's literally Christopher Rufo said on Twitter, I'm going to make people think everything is critical race theory. And then he went and did just that. And the media went right along with it. except for a few people. You know, I think Mark Lamont Hill had him on his show and absolutely destroyed him, and Christopher Rufo never went on that show again. But that's the sort of stuff that I think, you know, that journalists need to do. They need to speak the truth.
Also, I just have to say too, is that this idea, like, so for example, one of the like big anti-trans talking points is like, actually, like, you know, transness is converting all of these lesbians like into trans people. Arkansas actually like was making that case at trial, as if Arkansas gives a shit about fucking lesbians. And so it's like, guys, like, you're like, at least be like, and of course, notably, there are no sexual orientation protections in Arkansas. So like, expose it. And they say, like, Christopher Rufo attacked me on, you know, for criticizing marriage equality as a movement, as if he cares about marriage. Like, we can't just let them feed in wherever they want and not expose that they're pitting us against each other and we're just falling for it.
Same thing with the Black genocide narrative, right? Oh, abortion is Black genocide. There's so much abortion in the Black community, as if they want more Black babies around, right? Like, I know you're lying when you say you're concerned about the low birth rate of Black people in this country. Come on.
I'm sorry. Yes, I mean, I expose the people for who they are and how they are working together. This is a theme that Rewire News Group will be tackling pretty much all next year as well. The ways in which our institutions are tilting and being tilted towards this white Christian nationalist project and the harms that it is unleashing. We're already starting to see that from the conservative legal movement's response to the vote on the Respect for Marriage Act and their claims that, you know, this is actually going to help bolster their case against Obergefell. So to some of the points that the panelists have made already in this program, they are absolutely not stopping here this term with anything. This is, it's been unleashed. The genie is out of the bottle. We only have a couple minutes left, so I want to, first of all, thank you all for your time and your brilliance, and you're willing to just get in it. There aren't a lot of folks who are comfortable criticizing the court to the degree that Imani and I do. And so we were grateful to have some real brilliant friends join us and do that. And then I wanted to just give each of the panelists an opportunity to just kind of have a last word. We're all lawyers. There is nothing better than giving the lawyer the opportunity to have a last word. But if there's one thing that you would just really hope that the folks who were listening in, or maybe will catch this later, can get out of this conversation, or the work that you're doing, or something, you know, right now that's very important to you, here's your opportunity. You each get the mic. Andrew, I'll start with you because you're the first of my panels.
Yeah, I mean, I think I'd like to just try to tie it all together, because, you know,
Yeah.
They are raging against the dying of their privilege. That's what's happening. It's conservative, white, cishet Christian America is on a crusade to regain and reclaim the lost power and privilege and deference which it believes the rest of us owe it. Go listen to Alito's speech in Rome from back in July if you don't understand that. This isn't, I mean, so it's not really about one nation under God. It's about one nation under the straight white Republican Jesus. That's what we're talking about here. And the goal really is to create two classes of people: them, the conservative, straight white Christian men, and everybody else. And because basic demographics and the electorate does not reflect their narrow exclusionary beliefs, they're left with two options. And the first we saw on January 6th, right? Violence. And the second option is the hostile takeover of the courts. I mean, and this is what they did. This was remarkably successful. I mean, Leonard Leo, we didn't really talk about him. I think he's worth mentioning here at the end.
Yeah.
Ran the Federalist Society Judicial Crisis Network. His mission was described by a former employee like this. The employee said, he figured out 20 years ago that conservatives had lost the culture war. Abortion, gay rights, contraception. Conservatives didn't have a chance if public opinion prevailed, so they needed to stack the courts. Mm-hmm. And they did. And I mean, pay attention to the anti-democratic mission and goal inherent in that. If they didn't stack the court, the majority would rule. If they didn't stack the court, democracy would work. And we know their group spent $540 million from 2014 to 2020 packing the court. Leo's job during that time was described as the, quote, monitor of the nominee's ideological purity. The monitor of the nominee's ideological purity. I mean, he put Roberts and Alito and Gorsuch and Kavanaugh and Barrett on the bench. Thomas is an old friend. There's actually a video of him and Thomas at a Federalist Society event in Texas I was watching the other day. They're joking about how Leo's the third most powerful man in America. You know, all six of them are members of the Federalist Society. Yeah, just hilarious. I mean, that's 6 votes on the Supreme Court, and Leo personally chose 5 of them for their ideology, and it's this crusader ideology that we've been talking about. So, I mean, if I can only have people take away one thing from this discussion, it's that you've got to unshackle your mind from the belief that this Supreme Court is an impartial arbiter of truth and justice, right? The crusade that we've been talking about today depends on people believing that myth. And Trump and Leo and McConnell, they cheated and they stole and they packed the courts to put their collaborators in place, not because they would administer justice even-handedly, but because they wouldn't.
Precisely. It's an illegitimate court.
Yeah. So I'll leave it at that. It's hard to get off that soapbox, lawyer, captive audience.
Imani has coined the term the FedSac 6 for a reason. And I think that there is all the truth in that. Imani, I'm going to kick it to you.
I would just say that for people who are icky about LGBTQ rights, I'm speaking specifically to the Black community, they are coming for our rights too, right? You cannot separate the rights of lesbian, gay people to get married and the rights of Black people to marry outside our race. Like, it's just, you cannot separate those things. And part of this project, part of this white supremacist project, depends on convincing Black people to fall in line with that project, right? I mean, Herschel Walker is a huge example of that, right? They're going to find a Black face that they can control and then try to get others of us to fall in line with that. And if they're coming for LGBTQ rights, they're coming for interracial marriage next. And if you think Clarence Thomas won't invalidate his own marriage in favor, in service to this project, let's have a chat.
Chase?
Yeah, I mean, I think just related to those 2 final comments, like they consider their attack a collective one, but we haven't been good at considering our resistance a collective one. And that has been to our detriment. And so for all of the like cis white women who really are like really concerned about their reproductive rights, like your failures to engage in the erosion on the bodily autonomy of trans people contributed to the erosion of your own rights. That's always how it works. And it just never works to close the door behind you. You have to be engaged in a collective resistance project. They are so ready and willing to combine all of their attacks and move agilely from one to the other and connect them. And if we don't do that in our resistance, we're all going to lose.
Thank you all for your time, your brilliance, your insight, your work. It is a privilege and an honor to be in a space like this with all of you, truly. I mean that sincerely. And to the folks who took time out of their day today to join us in this wild and weird conversation about the court, thank you also. It's a Friday afternoon, depending on where you are. It's lunchtime-ish here in Colorado, but you know, I understand that you have other things that you could be doing with your time and you instead chose to spend it with us. And I am deeply grateful for that. Thank you for all of your support all year with, I'm speaking, you know, on behalf of Rewire News Group. We are the country's only nonprofit newsroom dedicated exclusively to reproductive health rights and justice issues. And the support we've received this year has been really phenomenal. We can't do it without you. You know, we try to put on programming like this as often as we can. We've got our podcast, we do special content drops. If you have the ability to support that work financially, you could go to rewirenewsgroup.com/donate. We would be grateful. Just truly to the panelists, thank you all for just being there for all of us in your various professional capacities. The world is a better place with you in it. And these conversations are so fun to just bask in the brilliance. So thank you all. Bye, folks.